because of his bless and mercy, we can come and join together without any obstacle with healthy condition in this third class of 3-in-1 as criminal law compartment program with topic the role of the examining judge. Firstly, let me introduce myself. My name is Ines Fatimah. I'm a junior lecturer and I am the moderator for today class. And participant, before we go to the presentation, let me introduce our lecturer, Professor Jan Kreins. He is a professor in criminal law and criminal procedure at the Institute of Criminal Law and Criminology of Leiden University, Netherlands, of which he is the academic director. He is also the research fellow in research program Criminal Justice, Legitimacy, Accountability, and Effectivity. So participant, you can deliver your questions directly to Professor Jan Kreins or send to the chat box in Q&A sessions after the presentation. So now maybe we can start your presentation, Professor. Time is yours.
Thank you very much. Thank you for your kind introduction. I hope you can hear me loud and clearly. Yes, okay, yeah, that's good to hear. And I also shared my screen, so I hope you can see the slides as well. Yes, okay. Well, let's start. If the computer is working, there it comes. Yes, over there. Yeah, it's the third lecture, of course, so it's good to see you all back. We are going to talk today on the role of the examining judge in the Dutch criminal justice system. An important topic, but maybe not as important as the topic of the second lecture, the role of the prosecutor. As I told you last time, the role of the prosecutor is has increased strongly in recent years, and now the prosecutor is the dominus litis in Dutch criminal procedure. But the examining judge still has an important position in a pre-trial procedure, but not as important as it used to be, as I will explain during this lecture. That means that we are going to talk today on actually two topics: the position and the tasks of the examining judge. But I don't need too much time for that, and one of that's why I chose to focus on a specific task of the examining judge, and that is ordering of pre-trial detention. And pre-trial detention is an important subject in the Netherlands because pre-trial detention is quite widely used in the Netherlands, quite easily. And from a perspective of human rights, you can be critical on that. Why do we use pre-trial detention so much in the Netherlands, while there is a right to freedom and, of course, the presumption of innocence? So pre-trial detention is heavily debated in the Netherlands. That's why I chose to discuss this topic as well for you today. So two main topics. I will start with the position and tasks of the examining judge. We call him the rechtercommissaris, as I showed you in the first lecture. And the position of the rechtercommissaris, of the examining judge, was very important in Dutch criminal procedure. In 1926, we started with the current Code of Criminal Procedure. There was a really important role, an important task for the examining judge in the pre-trial phase. Actually, in 1926, in our Code of Criminal Procedure, the division of tasks between the authorities was like this. The police became aware of a crime or a suspicion. Then he informed the public prosecutor, and from the moment the public prosecutor thought, well, this is an important case, we have to investigate this, he had to go to the rechtercommissaris, to the examining judge, and then the examining judge will start a gerechtelijk vooronderzoek, a pre-trial investigation, and then the examining judge would lead the investigation. He had most of the investigation powers, and the public prosecutor was, well, in the words of Faisal Afandi, a kind of a postman between the police and the examining judge, but the examining judge was the one who led most of the investigation and who had the most important investigation powers. Well, that is not the case anymore. As I showed you last lecture, the second lecture, the position of the public prosecutor increased significantly during the last decades. There are more and more investigation powers shifted from the impartial examining judge to the public prosecutor, and now most of the investigation powers can be ordered by the prosecutor himself. And the prosecutor is now the dominus litis. He will start the investigation, he will lead the investigation, and actually the role of the examining judge in current criminal procedure is just to assist the prosecutor sometimes in certain investigation powers, and he is also reviewing the legality of the investigation. So some investigation powers can only be ordered by the prosecutor after an authorization of the examining judge. So the examining judge has an important role, but it's more in assisting during the investigation, assisting the prosecutor, but also the defense, as I will explain later on. And he will review the legality of the investigation, but he's not the one who is leading the investigation anymore. That is the prosecutor himself. So that is why the examining judge is still important in Dutch pre-trial proceedings, but not as important as he used to be when we started with this Code of Criminal Procedure. I hope that is clear to you. Then I will show you some more specific tasks of the examining judge in Dutch criminal procedure, without mentioning articles in the Code of Criminal Procedure, because there are too many to show on this slide. Well, one task in the pre-trial phase for the examining judge is to review the investigation by authorizing for certain investigation powers. Most of the investigation powers can be applied by the prosecutor autonomously, but some investigation powers do infringe in such a heavy sense in the human rights of the citizen that the legislator chose to make these only available for the prosecutor after authorization of the examining judge. So, for instance, when the public prosecutor would like to wiretap the suspect, then he needs an authorization of the examining judge. Only when the examining judge say, okay, it's legal to wiretap the defendant in this case. Well, okay, only then the prosecutor may order this wiretapping. But the examining judge also has the power to conduct certain investigation I must say differently. The examining judge also has the option to apply certain investigation powers by himself. Some investigation powers cannot be ordered by the public prosecutor, not by anyone else, only by the examining judge. And then the prosecutor may ask the examining judge, would you be so kind to use this investigation power? For instance, conducting searches of a home. If the police would like to search someone's home, someone's house, then he needs the examining judge, and the examining judge will go to the house and lead the search of the house of the suspect. It's not allowed for the police or for the public prosecutor to conduct a search by themselves. They always need the examining judge, and the examining judge will lead the search of the home. The examining judge also has an important role in appointing expert witnesses, deskundigen. The public prosecutor in some cases may appoint an expert witness by himself, but in most cases he will need the examining judge to appoint an expert witness. And why is it important that an expert witness is being appointed by the examining judge instead of by the prosecutor? Well, of course, because of the need for impartiality. The examining judge is an impartial judge. The prosecutor is not impartial. So when it comes to an examining judge, when it comes to an expert witness, you will need an expert witness who is acceptable for the prosecutor and for the defense as well. So to include the interests of the defendant as well, it's advisable to appoint an expert witness by the examining judge, because then the defense can also influence which expert witness will be appointed. But the main task in the pre-trial phase for the examining judge is to hear witnesses. I told you in the first lecture that most witnesses in Dutch criminal procedure are being heard in the pre-trial phase, not during trial. We mostly hear our witnesses in the pre-trial phase, sometimes by the police and sometimes also by the examining judge. Of course, the hearing of a witness in most cases will be done in first instance by the police, but the problem is at the police, when a suspect is heard by the police, the defense will not be attending the hearing. But when the examining judge will hear a witness, then he can also invite the defense to the hearing. And then the defense, the lawyer or the suspect, the defendant himself, the accused himself, may also ask questions to the witness. So that is the main advantage of hearing witnesses by the examining judge, that you can also involve the defense. But still, you can be critical on this, because there won't be, in most cases, there won't be a hearing of witnesses during trial. So it's always, well, not always, but in most cases, the witness will be heard in the pre-trial phase without the public being able to attend the hearing. of course, when the examining judge will hear the witness in the pre-trial phase, only the public prosecutor will attend, and in some cases, the defendant as well. But it's an important role, and another advantage of witnesses being heard by the examining judge is that the examining judge may order the witness to come, and then the witness must obey to this order of the examining judge. He must come to the hearing and he must answer questions. And that is different for hearing witnesses by the police. When the police would like to hear a witness, they can invite a witness, but if the witness doesn't want to come and doesn't want to answer questions, then the police does not have any means to force the witness to come to the hearing and to answer questions. Well, the examining judge has the means and does have the means to force witnesses to come to the hearing and to answer questions. So that's an important task of the examining judge, hearing witnesses. Well, then there is another task of the examining judge in the pre-trial phase. He is watching over the completeness and the balance of the investigation. The investigation is led by the public prosecutor, as I told you in the second lecture. But the problem of an investigation that is led by the public prosecutor is that it can be an investigation from one perspective. And of course, there are also other perspectives. For instance, the perspective of the accused. Of course, the accused wants to have certain aspects of the case being investigated as well. So, of course, the accused wants to, well, he doesn't have to prove his innocence, but if he can prove his innocence, well, then the accused will be happy to do that. And then he can ask the examining judge to guarantee for a certain balance in the investigation, and he can ask the examining judge to order the public prosecutor to also investigate certain matters that are in the advantage of the accused. So it's not an investigation; is a search for the truth. It's not a means to get a conviction. Of course, when the accused is guilty, well, then the investigation will lead to information which points to the guilt of the accused. But if the accused is innocent, well, then you must investigate the innocence as well. Well, the pre-trial judge can watch over the completeness and the balance of the investigation by organizing meetings in chambers, regiebijeenkomst. He may ask the public prosecutor and the defense to come to his office and say, well, what do we have in this case? What are you doing, public prosecutor? What is the investigation going to? Is all information that must be investigated, is it actually investigated, also information which is in favor of the defendant? So the impartial examining judge may influence the investigation a bit by balancing between the interest of the criminal investigation and the interests of the accused. Are there any questions at this moment before we will go on with pre-trial detention?
Oke, mungkin ada pertanyaan.
Of course, there will be a Q&A at the end as well. But if there are any questions for clarification of the role of the examining judge, I will be happy to answer them now.
Yeah, there is no question in chat box already.
Okay, well then we will move on with the pre-trial detention, and of course you may raise questions on the examining judge as well later on during the Q&A. Because as you see on this slide, another task of the examining judge is to review the legality of the arrest and the initial custody of the suspect. When the suspect is arrested, he is arrested by the police, sometimes upon an order of the public prosecutor, and then he will go to the police station, and there he will be detained, and there he will be detained for a few hours or a few days. But after 3 days of detention, 3 days and 18 hours to be specific, then he must be led before the examining judge. The examining judge will review the legality of the arrest and the first days of detention. And when the examining judge finds that the arrest or the initial detention is illegal, he will order that the suspect will be released. So that is an important task, a task which also has a link with Article 5 of the European Convention on Human Rights, which guarantees each accused access to a judge, to an impartial judge, once he is detained. So in the Netherlands, an accused will not see the examining judge at the day of his arrest, but within 3 days and 18 hours, he must see an examining judge who will review the legality of his arrest and the first days of detention. And as I said, the examining judge will order the release of the accused when he finds that the arrest or the detention is illegal. For instance, because there's not, because the suspicion is not strong enough. But the examining judge will also do something else, or may do something else, when he finds that the detention and the arrest is legal. He may also decide to lengthen the pre-trial detention. He may order for a new term of pre-trial detention. And the first phase of pre-trial detention, ordered by a judge, ordered by the examining judge, we call bewaring in Dutch. And that is the first phase of pre-trial detention for 14 days, so 2 weeks. So after 3 days of detention upon arrest, ordered by the public prosecutor, then the next 14 days, the next 2 weeks of the pre-trial detention will be ordered by the examining judge. And that is what we call the first phase of pre-trial detention. And that is what I will discuss with you, because there are some debates in the Netherlands on pre-trial detention. And pre-trial detention is not only the 2 weeks custody ordered by the examining judge, but it's also the next phase of pre-trial detention ordered by the court. Because after 3 days ordered by the prosecutor, 14 days ordered by the examining judge, then the court will decide upon the pre-trial detention, and then the court will or may order the pretrial detention for some more weeks or some more months. So pretrial detention can last for months in the Netherlands. It also can last for years in the Netherlands. And that is exactly what raises questions in light of the right to freedom and the presumption of innocence guaranteed for in the European Convention of Human Rights. The debate in the Netherlands on pretrial detention actually is focusing on three problems. And you see you see these three problems here on the slide. Judges are give an extensive interpretation of the legitimate grounds for pretrial detention, and grounds are the goals, conditions for pretrial detention. Why are you ordering pretrial detention? Well, these legal conditions are interpreted by the judges quite extensively. So, and I will explain this later on. Another problem with pretrial detention in the Netherlands is that there is a lack of reasoning of pretrial detention decisions. Mostly the pretrial detention is ordered by the judge, but he's not explaining very extensively why he's ordering the pretrial detention. He's just ordering it, and then he will give some standard reasoning, but not a really good reasoning why in this specific case the suspect has to be detained longer than he is already being detained. And the third problem is lack of attention for alternatives to pretrial detention. And when we talk about alternatives, then you can think about bail, for instance, paying bail, and then the suspect will be will go out detention, will leave detention after having paid a certain amount of bail. That might be an alternative to pretrial detention. Another alternative, of course, is house arrest, electronic monitoring. You can order the suspect, well, you have to stay at home for the coming weeks or the coming month, and we are going to check that by electronic monitoring. So there are alternatives to pretrial detention, but they're not very much used, very widely used in the Netherlands. So these three problems I will discuss further with you. First, I look at the legal framework of pretrial detention. And this is the legal framework for the 14 days ordered by the examining judge, but also for the further phases of pretrial detention ordered by the court. Of course, the application of pretrial detention is bound to certain legal criteria. For instance, the existence of a strong suspicion of a crime of a certain severity. And these are mostly crimes which can be punished by a maximum of at least 4 years imprisonment. I see someone raising his hand or her hand.
Yeah. Sofa Umro. Yeah. Sofa. Sorry, Sofa.
Okay. Thank you, Ms. Finesse and Prof. Yan. Am I audible?
Yes.
Yeah.
Okay. Thank you for the explanation about the examining judge, and I want to ask about the examining judge. So as we know in ICC, the pretrial chambers can decide whether or not to issue warrants or arrest or summons to appear at the office of the prosecutor's request, and whether or not to confirm the charges against a person suspected of a crime. And they may also decide on the admissibility of situation and cases and on the participation of victims at the pre-trial stage and before the the the, the case the case continue to the trial stage, isn't it? And my question is there any difference in authority between the examining judge and the president judge or other judge, the presiding judge in ICC, and whose roles is the biggest? As what you presented before, the examining judge has a big role in the pre-trial stage, and are they the same person, the examining judge and the president judge, obviously in ICC? I think that is my question.
Okay. Thank you very
Thank
much
you.
for your question. I'm not very good into the procedure within the ICC, but what I can say is I think the presiding judge is the judge presiding the trial phase, right? Yeah. Well, there are differences between the examining judge and the presiding judge. Of course, we also have the trial judge in the Netherlands, and of course, the trial judge in the Netherlands may also order for certain investigation acts during the trial phase. But the examining judge has especially an important role in the pre-trial phase, in the investigation, but not in the prosecution decision. So the prosecution decision, what to do with a case, is a case brought to court, or is a case being settled by the prosecutor himself? That is a decision which is only upon the prosecutor. So the examining judge does not have any power when it comes to the prosecution decision. And I think that is different from the presiding judge, because the presiding judge, I think, has a certain role in deciding what to do with the case. And that is not a role that the examining judge has in Dutch criminal procedure. Is that an answer to your question?
Yeah. Thank you so much, Prof. Yan.
Okay. Yeah, thank you. Okay, one moment. The sun is shining in the Netherlands, which is, of course, good news. But it's better when we can see each other. Okay, so there are certain legal conditions for pre-trial detention. The first legal condition is the existence of strong suspicion of a crime of a certain severity, mostly crimes which can be punished by a maximum of at least 4 years imprisonment. Yeah, and you also need a strong suspicion, and we call that in Dutch ernstige bezwaren. You can translate that by severe crimes or something like that. There must be a strong suspicion against the suspect. And that is reasonable because you are going to detain someone, and well, then you must be, well, maybe not convinced of his guilt, but there must be strong information pointing to the guilt of the accused. And that is important for the next slide. There must be a legitimate ground for pre-trial detention. Pre-trial detention must have a good reason. And one of these the good reasons may be a risk of reoffending. You're afraid that the suspect will commit more crimes when you will release him. or there must be a risk of causing public disorder, and that means there must be outrage within the society when you will release the suspect, when you will arrest a suspect for a very severe crime, let's say manslaughter, and one day later you will release him. Now that will cause public disorder, that will cause outrage in society. People won't understand that. Another reason is the risk of absconding. You're afraid that the suspect will flee, he will disappear, he will go to another country, or he will hide himself. And the fourth legitimate grounds for pre-trial detention is the risk of danger to the investigation. You're afraid that the suspect will influence the investigation once he is released. For instance, by influenced witnesses, or for instance, by hiding evidence. So these are four legitimate grounds for pre-trial detention, and it is important that the examining judge, or later on the court, will review or will scrutinize these grounds seriously, because the main rule is that someone, that a suspect, may wait for his trial in freedom, because he's only a suspect. He's not convinced yet, or he's not convicted yet. There is no guilt being assessed. There's still a presumption of innocence. So the main rule is that you will let the suspect wait for his trial while he's in freedom. So when you order pre-trial detention, that is an exception to this main rule. So you have to have good reasons to detain someone. Well, these are the four reasons. The four reasons on the basis on which you can say, well, despite the general rule that someone has to wait his trial or may wait his trial in freedom, we nevertheless will place him in pre-trial detention. So there is a good reason to ask from the judge to review these legitimate grounds very seriously. Well, the critics on Dutch criminal procedure or the critics on the way we deal with pre-trial detention in the Netherlands is that we interpret these grounds very broadly. We easily say, well, there's a risk of reoffending. We quite easily say, well, there's a risk of absconding. We quite easily say, well, there's a risk of public disorder. And this leads to the fact that people are quite easily detained in the Netherlands or placed in pre-trial detention in the Netherlands. You see here some examples. For instance, the risk of reoffending. Well, it's quite common that in the Netherlands, the examining judge or the court will say, well, I'm afraid that you will reoffend. That's why I'm going to place you in pre-trial detention. Because you have a criminal record. You have a criminal record, and that criminal record shows that you have committed crimes before. And since you have committed crimes before, well, then there's a real risk that you will do it another time. So that's why I'm going to place you in pre-trial detention. Of course, there must be a suspicion of a new crime. That's the first criterion, the suspicion of a severe crime. But a suspicion of a severe crime and a criminal record may lead to the conclusion, well, there's a risk of reoffending, and that's why I'm going to place you in pre-trial detention. And this can also be the case. It's not only the case in very severe crimes like violence crimes and manslaughter, etc., but also in cases of theft, quite sometimes minor cases. The fact that you have a criminal record may be a good reason to place you in pretrial detention. Well, the risk of causing public disorder, that is described in the law as in the Dutch law as a suspicion of a crime which may be punished with a maximum sentence of at least 12 years imprisonment and which has seriously upset the legal order. So, if there is a suspicion of a crime with a maximum sentence of at least 12 years, and this crime has seriously upset the legal order, then you may place the suspect in pretrial detention. Well, that is not a great shock, I think. Crimes with a maximum sentence of at least 12 years are severe crimes, for instance, manslaughter. And in such a case, the legal order will be upset. So if you will place the suspect in pretrial detention on this ground, I don't think that will be a surprise to anyone. But the problem is, there are also severe crimes with a maximum sentence of at least 12 years that do not upset the legal order. For instance, drugs, the smuggling of drugs. Of course, when someone is suspected of drug smuggling in great amounts, well, then the legal order will be upset. But when a citizen has a small amount of drugs and he will go from Germany to the Netherlands and he has only a small amount, well, then the legal order will not be shocked by that fact. But nevertheless, the suspect can be placed in pretrial detention on this ground. And as you see, actually, these are two conditions: a severe crime with a maximum sentence of at least 12 years, and this crime must have upset the legal order. But the reality in practice is that we assume that every crime with a maximum sentence of at least 12 years will upset the legal order. So we make one condition of it, while legally these are two separate conditions. Well, and then the risk of absconding, the risk that the suspect will flee, will go away, will hide himself, will go to another country. Well, in practice, we say, well, if the accused does not have an official fixed residence in the Netherlands, doesn't have a specific place where we can find him, well, then there's a risk of absconding. So it's not that we assess, will this suspect really, is there a certain risk that this subject really will flee, really will go away? No, we just say, if you have a fixed residence in the Netherlands, well, then there's not a risk of absconding, because then we can find you. Then the police can go to your home and say, well, you have to come to court. But if you don't have a fixed residence, then the risk of absconding is assumed by the court or by the examining judge. And there's the risk of danger to the investigation. Well, this is quite easily accepted in the early stages of pretrial detention, in the first days or the first weeks. Then it's quite easily assumed there's a risk of danger to the investigation, because then the assumption is, well, when we will when we will release the suspect now at this moment, well, then he may influence witnesses or hide evidence or whatsoever. So maybe maybe we should first place the accused in pretrial detention, and after certain weeks, once we have finished the most important aspects of the investigation, well, then we can release the suspect, because then the suspect cannot endanger the investigation anymore. So these 4 grounds are legitimate grounds, but they are quite easily accepted in practice. Okay, and then the second problem is the poor reasoning of pretrial detention decisions. When you take a look at the Dutch Code of Criminal Procedure, then you read in Article 78 that the judge who is ordering pretrial detention must give reasons for this decision. He must explain, he must substantiate why he chooses to place the accused in pretrial detention. Okay, that is the code, but that's not the practice. In practice, pretrial detention decisions are often reasoned quite briefly and in general and abstract terms. And often it's a standard reasoning. The reasoning is just stating, well, the suspect does not have a fixed residence in the Netherlands, so there is a risk of absconding. The suspect does have a criminal record, so there is a risk of reoffending. Without asking yourself the question, or without explaining why in this specific case there actually is a risk of reoffending or actually is a risk of absconding. It's just standard reasoning, no fixed residence, so there is absconding, risk of absconding, no criminal record, so there is a risk of reoffending. There is a suspicion of a crime which is threatened by at least 12 years imprisonment, so the public order is threatened. And the European Court of Human Rights is critical on this practice in the Netherlands. Quite recently, last year, in February, the Netherlands was convicted by the Court of Human Rights for the poor reasoning of our pretrial detention decisions. Because the problem in these 3 cases, which you see on slide, was that each judge who was ordering on the pretrial detention decision was just made reference to the reasoning of the previous judge. So the first judge said, well, there is a risk of reoffending. Then the second judge, a few weeks later, would say, as the first judge already stated, there is a risk of reoffending. And then a third judge, as the previous judges said, well, there is a risk of reoffending. So the same reasoning was repeated several times by several judges without explaining why there still was a risk of reoffending. So these brief and standard motivations were, well, the European Court was critical on that. So in the Netherlands, we must make more work of the reasoning of pretrial detention decisions. And the third problem, like I already told you, is the lack of attention for alternative to pretrial detention. When you are afraid that the suspect will flee, will disappear, or when you are afraid that the suspect will reoffend and will commit further crimes when you release him, there are other options than pre-trial detention alone. You can also place the suspect in house arrest, and you can also order electronic monitoring. Then you will, then the suspect will get a bracelet, and when he will leave his home, when he is not allowed to leave his home, then there will be a signal at the police station, and then the suspect will be arrested. So electronic monitoring is an alternative to pre-trial detention, parole supervision as well, bail as well. Well, bail is not widely used in the Netherlands. It's more something which is used in common law countries like the United States and United Kingdom. Actually, I'm curious whether bail is being used in Indonesia. So if someone can explain me that later on during the Q&A, I would be very interested. But we're not using bail very much in the Netherlands because we're also afraid for class justice. We're afraid that people who have money will have the possibility to leave pre-trial detention, while people who don't have money don't have the possibility to pay bail and to leave the detention facility. And why are these alternatives for pre-trial detention neglected in the Netherlands? Well, one of the explanations might be that alternatives for pre-trial detention are shaped as conditions to the suspension of the execution of pre-trial detention. In the Netherlands, the system is as such: the judge is first asking himself, well, will I place the suspect in pre-trial detention? And once he decided to order the pre-trial detention, he may take a second decision and say, well, okay, I ordered the pre-trial detention, but maybe I'm going to suspend the execution of the pre-trial detention within certain conditions. So there's a possibility for the judge to say, well, I ordered the pre-trial detention, but nevertheless, I will release you, but I only will release you under certain conditions. For instance, electronic monitoring, etc., etc. So the alternatives to pre-trial detention are shaped in the Netherlands as conditions to the suspension of the execution of the pre-trial detention. And there's a good reason for that, because it prevents net widening. It prevents that you will order all kind of alternatives in all kind of cases, also in minor cases. But the problem is that you are only allowed to think about alternatives to pre-trial detention after you have ordered the pre-trial detention. So you must first have serious reasons to order pre-trial detention, and only when you have serious reasons for pre-trial detention, then you can think about alternatives for pre-trial detention. So they're somewhat hidden behind the conditions for pre-trial detention. So that may be a reason why the alternatives for pre-trial detention are not much used in the Netherlands so far. So when I conclude on pre-trial detention, then we can conclude that the legal framework of pre-trial detention in the Netherlands is fine, but the practice is more problematic, because we interpret the conditions, the legal conditions, quite extensively. and we quite easily order pretrial detention, while the main rule is that, because of Article 5 of the European Court, that there's a right to freedom and there's a presumption of innocence. So you might ask yourself whether the recent Article 5 violations in the Netherlands last year, of whether these are a wake-up call for the Netherlands to be more critical on pretrial detention, and to make more work of the motivation of pretrial detention of pretrial detention decisions. Well, I do not have an answer to this question yet, because these problems with pretrial detention in the Netherlands are quite harsh. In the first week, I already told you that in the Netherlands, the criminal proceedings are quite efficient, and because of this efficiency, we also well, we're also quite efficient on pretrial detention, so we don't like to substantiate pretrial decisions very extensively. Yes, and to conclude on the examining judge, the first part of my lecture today. Well, I think we can say that the examining judge is still a very important player within Dutch criminal justice. For instance, because he's the one who is hearing witnesses during the pretrial phase, and because he's the first judge who will decide on the legality of the first instance of detention, and who will also order the first phase of the pretrial detention. So there's still a very important role for the examining judge in Dutch criminal procedure, but this role is not as important as it used to be in the Code of Criminal Procedure of 1926. A lot of powers have been granted to the examining judge have been shifted to the public prosecutor in recent years. So now we must say that the public prosecutor is the dominus litis in the Dutch criminal procedure. But still, when it comes to safeguard for fair pretrial proceedings, to balance between the interests of the accused and the prosecutor, the examining judge still has an important role. So we shouldn't underestimate the role of the examining judge. His impartial role in Dutch criminal procedure is still significant. So I hope I've given you an insight in the role of the examining judge and more specifically in the discussions on pretrial detention in the Netherlands. And I'm happy to answer further questions, of course. So go ahead. And back to you, Ines.
Yeah, okay. Students, maybe do you have something that you want to question to Professor Jan Kreins? So far, good, maybe? Yeah.
I have another question.
Yeah. Yeah.
Okay.
Yes,
thank you for the time. Thank you for the time and the explanation, Prof. I do quick research on this Dutch criminal system, especially in judges and the public prosecution service. From what I research and what I read is, according the article, so the judge can also putting the question to examine the defendant and their lawyer if the defendants or lawyer appears. So my question is simple. So in Dutch system, Dutch criminal system, it is so the defendant and lawyer it is permitted for the defendant and the lawyer to not appear in the court. Yeah, maybe I repeat my question. Yeah. So the Dutch criminal justice system permitted the defendant and the lawyer to not appear in court. And if the defendant and lawyer not appear in court, so what the examining judge will do to this phenomena, according to the authority of the examining judge, to questioning them for this pretrial stage or pretrial chamber? That's my question.
Okay, thank you. So, if I understand correctly, your question is what is going to happen when the accused and his lawyer will not appear during court sessions? Well, I think you have to make a distinction between trial and pre-trial phase. In the trial phase, the defendant has the right to be absent. He's not obliged to come. So if he chooses not to appear for trial, well, that is fine. Of course, we would like, we're in favor of appearing, of course, because then we can ask questions, then we can have a debate, then we can discuss the case. And when the defendant is not showing up, well, then we have a trial in absentia. And well, yeah, then there is not a clash of opinions, and then well, then we only have the view of the prosecutor, and then a trial is not, yeah, then a trial is very brief, of course, and then we only have the perspective of the prosecutor, not of the defendant. So of course we would like the defendant to attend the trial, but he's not obliged to. And he can also send his lawyer only. So that's also an option, that the lawyer is attending a trial, but the defendant is not. That's also an option. Another option is that the defendant is coming, but his lawyer is not attending. That's also an option. But in the pre-trial phase, then the examining judge who will ask, who would like to ask questions to the defendant, he has the power to force the defendant to come. So in the pre-trial phase, the suspect may be forced to come to the examining judge to answer questions, but he does not have to answer them, but he is obliged to appear for the examining judge. But that is the pre-trial phase. In the trial phase, he's not obliged to attend the trial. Is that an answer to your question? Yeah.
Thank you so much. Yeah.
Thank you. You're welcome.
Yeah. So another question, maybe. It's okay to Professor Jan Krijns?
Yeah, of course. Go ahead.
Yeah.
And you can also use the chat when you prefer.
Yeah, kamu bisa chatting ya. You can give your questions in chat box. Mahasiswa, silakan. Can I give you a question?
Yeah, of course.
Professor. Yeah, thank you. So a couple of weeks ago, I just knew case from my student that accused is punished by court with 4 months jail or go to correctional institution, but he is already 8 months in detention. Yeah. So my question is, is there any institution in Netherlands to handle this case or examine this case, because the detention is longer than longer than decision.
sentence.
Yeah.
Yeah, I understand the question. Well, in the Netherlands, there is a sorry. There is an option to pay damages for the government that the pretrial detention is ordered while the suspect is being acquitted by the court. So when you're a few months in pretrial detention, and then the court will or the court is acquitting the accused, then the accused can go to court and ask for damages. So the government has to pay money because the government placed the defendant in pretrial detention while he was being acquitted. But that's only the case when there is an acquittal. It's not the case when the pretrial detention is longer than the sentence. So in your example, when you're placed for 8 months in pretrial detention while the court eventually is ordering for 4 months imprisonment, well, and then it's just a pity for the because in normal cases, of course, a pretrial detention will be the sentence will be shortened by the pretrial detention. So if you're placed in pretrial detention for 3 months, and then the court will sentence you to 6 months imprisonment, of course, the 3 months pretrial detention are already being executed, and then you only have to be in the prison for another 3 months. But when it's the other way around, when the pretrial detention is longer than the sentence, well, yeah, then just pity. Sorry for the accused, but that is how it works. So then there's not an option for paying damages or something like that. Is that an answer to your question?
Yeah. Thank you.
Okay.
Any questions, maybe? We have 59 participants here. Yeah. If not, can I closing the class, Professor?
Yeah, I think so. I hope it was clear to you. And if there are questions on what I've told you today, and if they are raised in the coming, or if there are raised questions in the coming days, please feel free to ask them in the next lecture.
Yeah.
We will see each other, I think, next Friday for the 4th lecture.
Yeah.
Okay.
Actually, Professor, we examining judge is not exist in Indonesia, but maybe we can find it in our criminal procedure draft criminal procedure, in our draft criminal procedure. And I think we already have a concept just like yours in your country, but yeah, so your information today is very informative and give our maybe just like maybe we can critics our concepts before we sorry, can you find some word before we run it with the as our criminal procedure. So yeah, your concept and your information about examining judge today is very useful, and I think we can give a discussions more for students about your concept and also our concept in our draft, just like that.
Yeah.
So yeah,
It's good to hear.
Yeah,
Well, it's in the Netherlands a role which is shifting all the times, but I think it's important to have an impartial judge in the pre-trial phase as well, because you have an impartial judge in the trial phase. That is of course important, but in the pre-trial phase it can be important as well. So I think it's good that in the draft of your new code you are discussing some role of a pre-trial judge. And of course, we are happy to think about it with you.
Yeah. So.
Okay, thank you very much.
Yeah, thank you, Professor, for today class, and we will see you in December, right? In 2nd December for the.
Yeah, it was on the program. Yeah. December the 2nd on Friday next week.
Yeah. With the what topic? With the criminal case dismissal and restorative justice. Yeah.
Yes, exactly. Yeah. And then I will also talk on the role of the victim in that criminal procedure.
Okay. Yeah. So I'd like to thank you, Professor, for give a very interesting and informative material in your presentation, and for participant, thank you. Sofa, thank you. And hopefully this class will be beneficial for everybody here. Amin. And see you next week here, next month.
Thank you very much, and you're welcome, and thank you all for attending. Bye-bye.
Bye.
Hey.
Disapa lo.
Iya.